In this video, I'll show you. On March 9, 2024, Sergeant Joe Beers of the Oilton Police Department in Oilton, Oklahoma, received a call regarding 3 individuals who were soliciting solar panels within city limits in violation of Section 4-4-15 of the Oilton Code of Ordinances. After Sergeant Beers found one of the solicitors within city limits, she advised that the other 2 individuals were driving around and provided Sergeant Beers with a description of the vehicle. A short time later, Sergeant Beers found the vehicle parked in the driveway of 76-year-old disabled Vietnam veteran Willard Walbridge's home, which is located just outside of Oilton city limits. Sergeant Beers got out of his patrol vehicle and began to speak with the solicitors who were sitting in their vehicle in Mr. Walbridge's driveway. Mr. Walbridge asked Sergeant Beers to leave his property, and the interaction that followed was captured on Sergeant Beers's body camera.
You're gonna be the one that's gonna be the one that loses, okay? So you need to step back, okay?
I won't be the one. Hey, I ain't stepping back.
You need to step back.
Son, I'll take your head off.
Okay? You need to step back.
I ain't stepping back. You're on my
907
place.
County.
Get the hell out of here now.
All right. You need to step back.
You understand that?
You need to step back.
Get the hell out of here now. You're on my place.
Okay.
You interrupted.
Do we want to go this way?
Do you want to go this way?
I was making contact with somebody who was soliciting, and I have another suspect here that's starting to get irate. I'm probably gonna have to go hands on. All right, keep your hands out of your pockets.
No, you're on my place. I ain't getting my hands out of nothing.
Let me explain something to you, okay? I'm dealing with something totally different, okay? Whether it's in the county or not in the county, it started in the city, okay? That's where we are. I'm going to be straight to the point.
Did you ask my permission?
I do not have to have your permission.
Place? You damn sure do. This is my place.
I'm going to tell you one more time to step back, okay?
This is my place.
Step back.
I'm not stepping back. You get the hell in your truck and get out here now.
Mr. Walbridge repeatedly asks Sergeant Beers to leave his property, and Sergeant Beers refuses, claiming that he does not need Mr. Walbridge's permission to be on his property. The Fourth Amendment protects citizens from unreasonable searches and seizures in their houses. Now, although these Fourth Amendment protections extend to the so-called curtilage of the home, which is the area immediately surrounding and intimately associated with the home, courts have consistently determined that some areas of an individual's property that are outside their home and its curtilage are not protected. By the Fourth Amendment here, Sergeant Beers approached the solicitors in Mr. Walbridge's driveway, which a court would likely conclude was not a part of the curtilage of Mr. Walbridge's home. As the Court of Criminal Appeals of Oklahoma summarized in the 1982 case of Finch v. State, quote, "A reasonable expectation of privacy, not common law property distinctions, controls the scope of the Fourth Amendment." Now, when it comes to driveways, the court went on to explain that, quote, "A driveway is only a semi-private area." The expectation of privacy a possessor of land may reasonably have while carrying on activities on his driveway will generally depend upon the nature of the activities and the degree of visibility from the street. It would be equally unwise to hold as a matter of law that all driveways are protected by the Fourth Amendment from all penetrations by police officers as to hold that no driveway is ever protected from police incursions. The test in each case would be that of reasonableness, both the possessor's expectations of privacy and of the officers as reasons for being on the driveway similarly in. In the 2003 case of U.S. v. Hatfield, the 10th Circuit Court of Appeals, which has jurisdiction over Oklahoma, determined that, quote, "The openness and accessibility of a driveway to the public has been an important factor that courts have used to conclude that an owner does not have a reasonable expectation of privacy, and that, now quoting again, driveways that are readily accessible to visitors are not entitled to the same Fourth Amendment protections as are the interiors of defendants' houses." In other words, although Sergeant Beers had entered onto Mr. Walbridge's property when he approached the solicitors in his driveway, Given the fact that the driveway was open and accessible to the public, it is likely that a court would conclude that Sergeant Beers' initial entry did not constitute a Fourth Amendment violation. However, Mr. Walbridge could argue that after he asked Sergeant Beers to leave his property, his implied invitation to enter the driveway was terminated, and that Sergeant Beers' refusal to leave the property constituted a violation of his reasonable expectations of privacy and therefore the Fourth Amendment. However, this would have to be debated in court.
Turn around and place your hands behind your back. That is a lawful order.
You put your hands on me.
Turn around.
I'm taking your head off. You understand that, son?
Turn around. Place your hands behind your back.
I'm not doing it.
907 County got one fighting. Turn around. Place your hands behind your back. Well, your husband does not want to listen. All right, listen. I'm going to turn you around. We're going to cuff you up.
You got a lot of cuffs me.
Just make sure this other guy that's back here doesn't come up behind me.
Did you get my nitro?
You need your nitro? Hey, he needs nitro. They're coming.
Mr. Walbridge refuses to move out of his way. Sergeant Beers orders Mr. Walbridge to put his hands behind his back, and when Mr. Walbridge does not comply, Sergeant Beers takes him to the ground, triggering an apparent cardiac event. Section 540 of Title 21 of the Oklahoma statute states that, quote, any person who willfully delays or obstructs any public officer in the discharge or attempt to discharge any duty of his or her office is guilty of a misdemeanor. It is possible that if Sergeant Beers had been within the territorial jurisdiction of his office, a court could find that Mr. Walbridge delayed or obstructed Sergeant Beers by preventing him from speaking to the solicitors, although Mr. Walbridge would have a strong argument that he was simply exercising his rights as a property owner. However, as we discussed earlier in this episode, because Mr. Walbridge's home was located outside of city limits, Sergeant Beers was outside of his jurisdiction while he was attempting to conduct his, quote, UN, quote, investigation. Therefore, if he was charged for obstruction, Mr. Walbridge could defend himself by arguing that Sergeant Beers was not discharging any duties of his office since he did not have the lawful authority to conduct an investigation of Mr. Walbridge's property. Additionally, in the 1990 case of Ross v. Neff, the 10th Circuit Court of Appeals held that, quote, an arrest made outside of the arresting officer's jurisdiction violates the Fourth Amendment to the Constitution, and that now quoting again, a warrantless arrest executed outside of the arresting officer's jurisdiction is analogous to a warrantless arrest without probable cause. Absent exigent circumstances, such an arrest is presumptively unreasonable. As such, it is likely that a court would conclude that Sergeant Beers' arrest of Mr. Walbridge outside of his jurisdiction was unconstitutional, even assuming for the sake of argument that he did have probable cause to arrest Mr. Walbridge for obstructing. Additionally, Mr. Walbridge would have a strong argument that Sergeant Beers' use of force was excessive, also in violation of the Fourth Amendment. As we have discussed many times on ATA, when determining whether a use of force is excessive, courts must consider three factors that the Supreme Court outlined in the 1989 case. The case of Graham v. Connor, now quoting the severity of the crime at issue, whether the suspect poses an immediate threat to the safety of the officers or others, and whether he is actively resisting arrest or attempting to evade arrest by flight. At most, the crime at issue was the obstruction of an investigation of a solicitation violation. Although Mr. Walbridge made verbal threats, he did not take any physical action against Sergeant Beers before the initiation of force, and although he refused to comply with commands, he did not physically resist or attempt to. As such, a court could conclude that not only was the arrest itself unlawful, but that the amount of force Sergeant Beers used to effect the arrest was constitutionally excessive.
Well, he's looking for you guys.
Yes, sir.
I just can't have you over here threatening me and telling me.
Okay, give me the pill. Give me the pill.
He's got to go in his.
I know. Willard,
Willard, in your mouth, okay?
Here.
Week of 1.
You do.
You got it?
Put 1.
You do.
That's your 2. That's number 2.
You do.
Sorry. I can't do nothing. I'm just totally helpless. Sorry. It's okay. Thank you.
Willard.
Let's back off and let him calm down. Okay. Maybe it'll help. I ain't been disrespectful.
No, you're
back
good.
off and let him be.
Will you sit down here?
He's got problems. He doesn't need any more.
I'm not trying to give him any more. I wasn't trying to get it to this
Back
point.
off and talk over there for a minute, please.
I'm going to need you guys to stay here for a minute. I'll probably need a statement from you. Okay.
What is the deal that you're here? I don't get it.
So, somebody called in saying that there were solicitors going around.
So?
They gave this vehicle.
Okay.
So I made contact with these guys.
Okay.
It happened in the city. And your husband, is this your husband?
Yes.
Came up, basically told me to get the fuck off his property. This is county property. Started threatening me.
Property for talking to
Does
somebody? Is it okay, isn't it?
Well, there's an incident that happened prior to that. So take it in this concept. If these guys murdered somebody in the city, and then they came over here and were talking to you, would we not come here and apprehend them?
I don't know what you do.
Sergeant Beers claims that he had the authority to continue his investigation on county property because the solicitors had initially broken the law on city property. As the Court of Criminal Appeals of Oklahoma explained in the 2004 case of United States v. Sawyer, quote, "Generally, a police officer's authority cannot extend beyond his jurisdiction. Recognized exceptions to this general rule are hot pursuit, when one municipality has requested assistance and when an officer is serving an arrest warrant. Otherwise, once outside the city. Limits of the municipality by which they are employed. The officer acts as a private citizen with no greater authority than that of a private citizen here. It is indisputable that Sergeant Beers was not responding to a request for assistance from another municipality or serving an arrest warrant. And it is also probable that a court would likewise conclude that he was not in, quote, UN, quote, hot pursuit of the solicitors. According to the U.S. District Court for the Western District of Oklahoma, in the 2016 case of Madden versus Cleveland County, quote, hot pursuit occurs when an officer is in immediate or continuous pursuit of a suspect from the scene of a crime, and while Sergeant Pierce was looking for the solicitors, he had not chased them from a crime scene, which means that a court would likely find that the narrow exception for hot pursuit did not apply. Additionally, the hot pursuit exception allows officers to make arrests outside of their jurisdiction, not conduct investigations. For instance, in the 1977 case of Graham v. State, the Court of Criminal Appeals of Oklahoma invalidated a warrantless search of a residence conducted by a police officer outside the corporate limits of his jurisdiction, finding that none of the exceptions to the general rule limiting the policeman's authority to his jurisdiction were applicable. Because Sergeant Beers was attempting to conduct an investigation and not attempting to arrest the solicitors, a court would likely find that the hot pursuit exception did not apply, and that Sergeant Beers was therefore acting outside the scope of his authority.
Gave him 2 nitros. I called for an ambulance. I called for drum right before I ever had to go physical.
You still need me for anything?
Well, I told him it's in 22. Hey, hold on 1 second. I was trying to get somebody here before it got to this point, so.
Okay. Yeah, they sent me all the way to like 4th on the east side of town, and I'm like, I don't know where he is.
I told him between Main and 3rd off of Westwood.
Yeah, they said between Main and 3rd, Westwood never came out. So.
Okay.
All right, man. If you don't need me, I'll head back.
Yep, you're good. I appreciate it. Let me talk to the ambulance. I'll call you back. Okay. Basically, we had to get physical. Went to the ground. He said he needed his nitro, and so I hollered for his wife to get his nitro. They gave him 2 pills and tried to get it. He was on his side, so they were tucking him. And then we've been here at this whole point. So, okay. I'm good, but I just need him to take care of me.
Mr. Walbridge did not suffer any serious complications from the cardiac event, although he reported that his wrist and finger were bleeding and that he was, quote, UN quote, bruised up when he regained consciousness in the ambulance. In a media interview, Mr. Walbridge stated that he had filed complaints over the incident but had not yet considered taking legal action. He was not charged with any crimes. On March 23, 2024, the Oilton PD shared partial body camera footage of the altercation on its Facebook page, along with a statement defending and supporting Sergeant Beers' actions. The statement indicated that Sergeant Beers was, quote, UN quote, forced to physically take Mr. Walbridge into custody, quote, for his own safety and the possible safety of the public, and stated that, quote, it is unfortunate that these events had to take place, but it is the opinion of this department that Sergeant Beers acted accordingly based on training and officer safety as a full-time State of Oklahoma CLETE certified police officer. Despite the apparent support of his department, Sergeant Beers resigned from his position on April 9, 2024. The encounter was reported to Creek County District Attorney Max Cook, who confirmed that he was reviewing the body camera footage and investigating. As of the date of writing this episode, no charges have been filed against Sergeant Beers and no updates regarding the DA's investigation have been made public. It should also be noted that while Guerrilla Publishing was investigating this encounter, they uncovered a substantial amount of corruption involving now former Oilton Police Chief Carl Stout, who defended Sergeant Beers' actions in his encounter with Mr. Walbridge, including a long history of domestic violence and sexual misconduct allegations. On April 30, 2024, Chief Stout's wife filed a protective order against him, and on May 14, the Oilton City Council voted to terminate Chief Stout for cause. Guerrilla Publishing has released a documentary on their complete findings, and I have included a link in the description for this episode if you're interested in learning more. Overall, Sergeant Beers gets an F for demonstrating a complete lack of regard for the boundaries of his jurisdiction and Mr. Walbridge's rights. As a property owner, using an excessive and unjustifiable amount of force against Mr. Walbridge and failing to exhibit any remorse for his actions that caused an elderly veteran to suffer an apparent cardiac event. Even if Sergeant Beers was entirely justified in arresting Mr. Walbridge, which, to be clear, I do not believe he was, the amount of force he used against a passively resisting elderly man on his own property was unnecessary and unconscionable, particularly given the fact that that crime he was investigating was nothing more than a potential solicitation violation. There are many actions that Sergeant Beers could have taken to de-escalate this situation, such as complying with Mr. Walbridge's request that he leave his property and requesting the solicitors to come with him. Sergeant Beers could have also used the solicitors as license plate information to continue the investigation at a later date, or requested that the county police respond and assist him. Instead of availing himself of any of these alternatives, Sergeant Beers chose to remain on private property outside of his jurisdiction after being asked to leave. Without a warrant or exigent circumstances, and use substantial physical force against an elderly homeowner who was attempting to protect his property from an unreasonable intrusion by a police officer. This conduct was entirely unjustifiable, and I am relieved that Sergeant Beers and Chief Stout are no longer employed by the Oilton PD. Mr. Walbridge gets AB-, because while he did make threats of physical violence against Sergeant Beers and resisted Sergeant Beers' attempts to arrest him, he was likely within his rights to resist the arrest under Oklahoma. Although citizens can be arrested for resisting an unlawful arrest in many, Oklahoma jurisprudence recognizes a right to reasonably resist an unlawful arrest. Now, of course, there are limitations to this right, and citizens can still find themselves in legal trouble if they attempt to resist an arrest they believe is illegal that a court later determines to be, if the physical resistance exceeds the bounds of what a court believes to be. Quote, UN quote, because Sergeant Beers was attempting to arrest Mr. Walberg. Outside of his jurisdiction, it is likely that a court would conclude that in this situation, Mr. Walbridge was well within his rights to reasonably resist the arrest. That being said, I cannot support making threats of physical violence in most situations, and I would suggest that individuals do not resist arrests, even in states that allow citizens to resist unlawful arrests, as there is a substantial risk of criminal conviction if a court disagrees with the citizen about the lawfulness of an arrest, or the reasonableness of the force used in resistance. Let us know if there is an interaction or legal topic. Thank you very much for watching the video. Subscribe our channel for next video.